This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why insurance fraud is a violent crime and why a murderer guilty of killing for insurance money must serve the full 60-year sentence imposed by the U.S. District Court. It is absolute chutzpah, unmitigated gall for a defendant to kill his girlfriend and then try to collect the life insurance money. And while he's doing so, setting a few arson-for-profit fires, and then claim he was wrongfully sentenced. Ronald Epps, a prisoner in federal custody, filed a motion to vacate, set aside, or correct his sentence, as well as a filing he called a motion for compassionate release. In a case called Ronald Epps versus the United States of America, a decision of the United States District Court for the Western District of New York that was rendered on February 13, 2024. Epps was charged in a 3-count superseding indictment with maintaining premises for the purpose of manufacturing and distributing narcotics, with possession of a .32 caliber revolver and furtherance of drug trafficking, with possession while previously a convicted felon of the same firearm. In addition, the narcotics and firearm charges arose after a search warrant was executed as part of the investigation of the murder of Miss Moss by a gunshot to the back of her head. Epps was later charged with 7 additional offenses, beginning with wire fraud for exercising a scheme fraudulently to collect the proceeds of a life insurance policy on the life of his girlfriend, Ms. Moss, with mail fraud for executing a fraudulent scheme to collect proceeds of a renter's insurance policy covering the premises after the premises had twice been damaged by intentionally set fires, and with 5 specific arson-related offenses in connection with those fires. A jury was conducted before the United States District Court, and the jury returned guilty verdicts on all counts. Epps was sentenced to an aggregate term of 60 years in prison. The final judgment was entered on January 4 of 2017. Epps, pro se, timely filed a motion to vacate, set aside, or correct his sentence. The trial evidence showed that Epps drove Miss Moss to her job at a healthcare facility in Orchard Park, New York on August 27, 2009. After Ms. Moss' body was found on the morning of August 28, police conducted a search of Epps's residence at 21 Cascade Drive and found and seized the .32 caliber revolver underlying the 2 charged firearm offenses set forth in the indictment. Evidence about Epps's actions and the statements involving a so-called, quote, bag of guns, close quote, tended to explain why the 9mm firearm used to shoot Miss Moss in the back of the head was not recovered by law enforcement when they searched Epps's residence. Defense counsel's strategic decision to agree to the consolidation of the 2 indictments, the one for the gun charges and the one for murder, in hopes that it would influence the court to grant her motion to sever and allow her to try at least 1 indictment free of any evidence regarding Epps's possession of firearms, was reasonable. Notwithstanding that such strategy was rendered unsuccessful by virtue of the court's decision to consolidate and not sever, such outcome hardly renders defense counsel's performance constitutionally ineffective, as Epps claimed. With the direct appeal establishing the legal correctness of the court's evidentiary ruling, The court further found that a single apt analogy referenced by the court outside the presence of the jury in connection with its ruling does not, based on Epps' disapproval alone, constitute partiality. Judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. Also, the court concluded that Epps was not entitled to compassionate release because even though a court can modify a term of imprisonment once it has been imposed, except by and pursuant to statute, Epps failed to establish, as he must, that extraordinary and compelling reasons warrant reduction of his sentence. Finally, Epps has failed to establish, as he must, that the applicable sentencing factors under Section 3553A do not, on balance, cut against any reduction. Based on these deficiencies, his motion for compassionate release was denied. In my opinion, I have been told by prosecutors over the last 55 years that they don't want to prosecute insurance fraud because they need the time to prosecute violent criminals. Mr. Epps killed his girlfriend to collect insurance money while simultaneously setting fires to profit from his crimes, fires that could have resulted in the death or injury of firefighters or neighbors. Two violent crimes, arson and murder, resulted in a sentence of 60 years only to allow the defendant to waste the time of the court with a pro se motion to set aside the judgment because the judge was prejudiced against him, his lawyer was inadequate, and he needed to be released from prison. Fortunately for the public of the United States, his ploys failed and he will stay in prison for the next 60 years because insurance fraud is either a violent crime or, as this case showed, the reason for two violent crimes. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog when you click on that URL, and you will be advised of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos at YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please subscribe for a very small fee to my Substack publication. Thank you for your attention.